So we wanted to show next a side-by-side comparison of a will versus a trust.
That sounds like a good idea.
All right.
That's there you go.
So here's a comparison of a will versus trust. A will, these are just reviewing what we've already talked about, but a side-by-side. A will is public record. A trust is private to the trustees and successor trustees. A will requires probate and involves courts and lawyers. And a trust can completely avoid probate and avoids courts and lawyers. A will can be expensive and takes a lot of time to go through the probate process. A trust is cost efficient and time efficient for your beneficiaries. A will can pretty easily be contested in the probate court, and also can pretty easily be contested because, again, the probate court is an open process. A trust is, again, the business of the trustees and private to the trustees. And it can be contested, but it's a lot more rare. You can also include in a trust a no contest clause that basically says, if any of my beneficiaries or anybody wants to contest what I have laid out as my wishes in this trust, they only get $1. Because then if it's a law specific thing that if they contest something,
Right.
they can get something, but then the trust says all they get is $1 to avoid that. And then lastly, a will complicates asset transfer by involving the court process. A trust simplifies the asset transfer and makes things smooth for your beneficiaries.
So how do we set up a revocable living trust? That's what our next slide shows, I think.
Yep.
Is that right?
So these are the steps to setting up a revocable living trust.
So first off, you have to decide on who the successor trustee or trustees are and who the alternates are, and who the POAs, that stands for power of attorney, who the powers of attorney are for finances and for healthcare. The power of attorney applies for while you're alive, and if you are incapacitated or incompetent. And so the assets that are in your trust are going to be taken care of by the successor trustee if you're incapacitated or incompetent. But you're going to have stuff that's not in your trustee or in your trust by design, like your IRA. We don't want that in your trust. But let's say that I have an IRA and I get the Alzheimer's and can't take care of myself. The power of attorney for assets, your mom, Angela, can manage and distribute that IRA for my benefit for me because she's the power of attorney for assets. Same thing. Everybody knows what a power of attorney for healthcare is. So number 2 is
draft the legal documents, and we can help direct you with that, whether you have that done. A lot of times they're done by an attorney. Third,
we do them a lot online with people with an online thing that works and that they like and that's inexpensive.
That has online lawyers. Yep.
Yep.
Third, you have to sign those legal documents a special way. They have to be witnessed by a notary and 2 witnesses.
And we help people with that. We call them a signing powwow. It takes about 45 minutes to sign and witness and notarize all the documents and all that stuff. We do it here in the office. And then number 4, you need to fund the trust. What's the matter?
That's how all the stuff gets into your trust.
Right.
Is by this process. It's super important.
Yeah. So you can have a trust and everything could be hunky-dory and everything, but if you didn't fund the trust, meaning changing the titles on the stuff you want to be in the trust, like when we did ours 25 years ago or whenever, we changed the title of our house from Bob and Angela Benny Joint Tenants with Rights of Survivorship to the Benny Family Trust. Same thing with ownership of Bob Benny Wealth Management. It's owned by the trust. Same thing with our vehicles, owned by the trust. Bank accounts, owned by the trust. All that stuff. So That's very important in order to get the trust to avoid or to get the asset to avoid probate. We don't want a dead person's name or a person's name that's eventually going to die on the title of the asset, because when they die, that's how stuff ends up in probate is if a dead person's name's on the title of it. Think about it. Your name is on the title of your car, or it's joint name, and your spouse dies. Now your name is on title of the car and you die. Now we have a titled asset, title in the name of the dead person. Nobody can sell it. Nobody can take it. It's frozen. It has to go through the probate process. That's what we're trying to avoid. The hassle of probate and the expense of probate.